Welcome to the latest Bond Dickinson Employment Law podcast. I'm Karen Plumley-Jones and I'm one of the practice development lawyers for the employment team here. In this podcast, I'll tell you about some of the major cases that have been reported since my last podcast, dealing with vicarious liability, references, and religious discrimination. Then I'll go through a couple of pieces of new legislation and the main employment law changes we expect to see in the rest of 2016, before looking at some news stories. Lastly, I'll give you some action points to take away with you. This podcast qualifies for CPD points, and you can claim for the amount of time you spend listening to it. My first case is Mohamud and W.M. Morrison Supermarkets plc, where the Supreme Court looked at the law of vicarious liability in the workplace in deciding whether a supermarket was liable when one of its petrol station employees violently assaulted a customer on the forecourt. Mr. Khan, who was employed by Morrison's to work in the petrol station, carried out a brutal and unprovoked racist attack on Mr. Mohamud. He was a customer who had asked Mr. Khan whether he could print some documents from a memory stick. Mr. Khan declined, using expletives. When Mr. Mohamud objected to Mr. Khan's language, Mr. Khan told him to leave the premises, then followed him out of the kiosk and back to his car, where he assaulted him. Mr. Mohamud brought a claim for personal injury against Morrison's. The Supreme Court upheld the claim. It found that it was Mr. Khan's job to attend to customers and respond to their inquiries. He was purporting to act in the business of his employer when he told Mr. Mohamud never to return to the petrol station, and he was wearing his Morrison's uniform when he attacked him. The court stated that the test was formed of two questions. What is the nature of the employee's job? And is there a sufficient connection between the position the employee holds and his wrongful conduct to make it right for the employer to be held liable? Morrison's had employed Mr. Khan in this position and were therefore vicariously liable for his actions. Employers will now be concerned that they will be held liable for violent and negligent acts committed by employees at work. In order to reduce the risk of such claims arising, employers should ensure that they carry out appropriate staff training, they have adequate supervision in place, and their policies make it clear that this conduct is not acceptable. Can vicarious liability go beyond the employment relationship and be established in employment-like relationships? This was the question before the Supreme Court in Cox and Ministry of Justice, where judgment was given on the same day as the Mohamud and Morrison's case. Mrs. Cox was employed by HM Prison Swansea to supervise civilian staff and prisoners working in the prison kitchen. A prisoner negligently dropped a sack of rice on Mrs. Cox's back, causing her injury. The prisoner was not employed by the prison, but was required under the Prison Rules 1999 to work 6 days a week in the prison kitchen, preparing meals for the prisoners. Mrs. Cox brought a negligence claim against the Ministry of Justice. The Supreme Court held the MOJ liable. It stated that vicarious liability can be established in employment-like relationships and not only in the case of employer and employee. It found that the prisoner was integrated into the operation of the prison and the activity of providing meals for prisoners. The prison service placed him in a position where there was a risk that he might commit a variety of negligent acts. This decision, like Mohamud, expands the doctrine of vicarious liability to cover a wider range of factual circumstances. One of the Supreme Court judges noted that this doctrine is on the move, leaving scope for it to become even broader in future. Employers should be aware that they may now be liable for acts carried out by non-employees. My next case is Abdel-Khalek and Ali, where the Court of Appeal had to consider a claim for negligent misstatement against a doctor in relation to a reference. Mr. Ali and Mr. Abdel-Khalek, who were both surgeons, worked together for about 4 months before Mr. Abdel-Khalek moved to another job. Mr. Abdel-Khalek was then offered a locum post at another hospital, but the offer was withdrawn after Mr. Ali gave an informal verbal reference in which he disclosed that Mr. Abdel-Khalek's complications and complaint rates had been higher than expected. Mr. Abdel-Khalek brought a claim for negligent misstatement against Mr. Ali. The Court of Appeal found that Mr. Ali had negligently misstated the number of patients who had suffered complications following surgery and the number of cases that were expected to result in litigation. However, it decided that the job offer had been withdrawn because the hospital trust had been given the impression that the complication rate had been higher than expected, which was a correct statement. The claim for damages for negligent misstatement was therefore dismissed. This case illustrates what can happen when informal verbal references are given, although it does helpfully confirm that mistakes in the detail of a reference will not necessarily lead to liability if the overall impression is generally accurate. Employers should ensure they have a reference policy in place and that reference requests are sent to a particular individual. The case is also a reminder to individuals that they can be sued personally for a reference given by them. Was the dismissal of a teacher who stood by her sex offender husband indirect religious discrimination? This was the question the EAT had to decide in my last case, which is Pendleton and Derbyshire County Council and the governing body of Glebe Junior School. Mrs. Pendleton, a practising Anglican Christian and a junior school teacher, was dismissed for not leaving her husband, the head teacher of another local school that was part of the same cluster group, when he was convicted of downloading indecent images of children and voyeurism. Mrs. Pendleton had an unblemished record, and there was no suggestion that she had been aware of her husband's activities. She had made her decision in the light of her marriage vows, including her commitment for better or worse. She was dismissed for gross misconduct and brought various claims, including indirect religion or belief discrimination. The EAT found that there had been indirect discrimination. The relevant practice was the school's policy of dismissing any employee who elected to stand by their spouse or partner in the circumstances that Mrs. Pendleton had faced. It was not relevant that this was the only time the practice had been applied. Having to choose between their partner and their career gave rise to a particular disadvantage for those with a religious belief in the sanctity of marriage vows. The school had adduced no evidence to demonstrate that dismissal was a proportionate means of achieving the legitimate aim identified, and so had been objectively justified. This decision is helpful in clarifying the circumstances where an employment tribunal might consider that a one-off disciplinary decision amounts to a provision, criterion, or practice. It also highlights the importance of correctly identifying the comparator groups for the purposes of identifying whether there was group disadvantage. Next, I'm going to look at two pieces of new legislation and the principal changes to employment law that we expect to see in the rest of 2016. The Immigration Act 2016 has received royal assent. The main provisions are extending the existing criminal offence of knowingly employing an illegal migrant so that it applies where the employer has reasonable cause to believe that a person is an illegal worker. This came into force on 12th of July, when the penalty on conviction increased from 2 to 5 years. Creating a new offence of illegal working, which also came into force on the 12th of July, this enables the earnings of illegal workers to be seized under the Proceeds of Crime Act 2002. Giving the Secretary of State the power to impose an immigration skills charge on certain employers who sponsor skilled workers from outside the EEA, which is expected to be introduced in April 2017, and requiring public authorities to ensure that public sector workers in customer-facing roles speak fluent English. No commencement date has been announced for this yet. The Psychoactive Substances Act 2016 came into force on the 26th of May. It is now an offence to produce, supply, or offer to supply, import or export any psychoactive substance if it is likely to be consumed for its mind-altering properties. Possession of a psychoactive substance is not in itself an offence unless it occurs in a custodial institution. The targeted substances are often referred to as legal highs. There is a list of exemptions which includes legal substances that are in everyday use, such as nicotine, coffee and alcohol, and medicines. Employers should review their drug and alcohol policies and amend them if necessary to include the use of psychoactive substances. On the 1st of October, the national minimum wage will increase so that the adult rate will be £6.95 per hour. The gender pay gap regulations are expected to come into force, and the cap on public sector exit payments may also be implemented. Sometime in the summer, the PRA and FCA final rules on regulatory references in the financial services sector are expected, and on the 7th of September, new rules on whistleblowing in financial institutions are due to come into force. The government has to implement the Disclosure of Non-Financial and Diversity Information Directive by the 6th of December this year. Lastly, shortly before being confirmed as Prime Minister, Theresa May said that she would change the system by which big business is scrutinised by having workers represented on company boards. We do not yet have details on how the arrangements will work, which organisations will be affected, or when it is likely to be introduced, but it is probably more likely to happen next year than this. And now some employment law news items. In June's referendum, the UK voted to leave the EU, and, as Theresa May has noted, Brexit means Brexit. But what does this mean for UK employment and immigration law? It will be at least 2 years before the UK actually leaves the EU, and until then, little is likely to change. After that, the government could decide to repeal or amend any of the employment laws that the UK was required to implement as a result of being part of the EU. This includes laws relating to discrimination, transfer of undertakings, family leave, collective consultation, agency workers, working time, fixed-term employees and part-time workers. However, it is unlikely that major changes will be made to laws that protect workers' rights, as there would be widespread opposition to watering them down. It is more likely that amendments will be made to laws that are seen as imposing unnecessary red tape on businesses. Future decisions of the ECJ will not be binding in the UK after we leave, and the ECJ will no longer have jurisdiction over the UK, so the Supreme Court will become the highest court. We will not be bound by future EU legislation unless this is negotiated as part of a trade deal with the EU. Employers are more likely to be concerned about changes to migration policy and how they may affect EU nationals working in the UK and UK citizens working in the EU. If the points-based system is extended to EU workers, it will be more difficult and more expensive to recruit employees from the EU in the future. However, it is possible that the UK will have to agree to the continued free movement of people in return for access to the single market. Alternatively, the UK may enter into reciprocal arrangements with other EU countries that give citizens permission to stay if they are currently working abroad. We will be covering the impact of Brexit on UK employment and immigration law at our September employment clubs. Do reserve a place if you'd like to hear more. The House of Commons Justice Committee has published the results of its review into employment tribunal fees. It found that fees have had a significant adverse impact on access to justice for meritorious claims. It recommended that there should be a substantial reduction in the level of fees and the remission scheme should be overhauled. The report criticised the government's delay in reporting on its own post-implementation review of fees, which is expected to be published shortly. Unison's appeal to the Supreme Court in relation to the judicial review of the tribunal fees regime is due to be heard on the 7th and 8th of December. ACAS has published the results of independent research on the effect of early conciliation on tribunal claims. It found that 71% of claims reported to ACAS did not proceed to a hearing following early conciliation, and of those who withdrew their claims, 27% said it was because they would not win or it would be a waste of time, 20% were put off by tribunal fees, and 17% found the process too stressful. Just over half of claimants said that taking part in early conciliation made it quicker to resolve their claim. The Trade Union Membership 2015 Statistical Bulletin has been published recently. Key findings include around 6.5 million UK employees, 24.7% of the workforce, were trade union members in 2015. Current membership levels are well below the peak of over 13 million in 1979. In the public sector, 54.8% of the workforce is in a trade union. This falls to 13.9% in the private sector. Female employees are slightly more likely than male employees to be trade union members. Older workers count for a larger proportion of union members than younger workers, and employees in professional occupations are more likely to be trade union members than other employees. There are several action points that you should consider as a result of the matters I've covered in this podcast. Check that customer-facing employees are adequately trained and supervised to reduce the risk of claims by customers. Be aware that your organisation could be vicariously liable for acts carried out by non-employees if they are in an employment-like relationship. Review your reference policy. Does it state that employees cannot give informal verbal references? Does it provide that reference requests must be sent to a named individual? Review your drug and alcohol policy and amend it if necessary to include the use of psychoactive substances. And start considering how leaving the EU may impact on your organisation, and reserve a place at one of our September employment clubs. See the events page on our website for details. I hope you found this podcast useful. Please get in touch with your usual Bond Dickinson contact if you have any queries. Thank you for listening.